Hello and welcome to Ex Parte Reexam as an alternative to Inter Partes Review, hosted by Virtual Patent Gateway and sponsored by Unified Patents LLC and Unified Network. Virtual Patent Gateway founder Ashley Chung has a passion for supporting the next generation in the workplace and is committed to developing a growth mindset within VPG. Today's panel discussion will be moderated by David Seastrunk, Senior Patent Counsel at Unified Patents LLC. David's practice focuses on post-grant proceedings before the U.S. Patent and Trademark Office and appeals before the U.S. Court of Appeals for the Federal Circuit. This webinar will be recorded for future use. There will be a short Q&A at the end of the presentation. And with that, I'll hand it over to David.
Great. Thank you, Caitlin. Good afternoon, everyone, and welcome to our panel discussion. My name is David Seastrunk. I'll be your moderator for the panel today. A couple things just to quickly get out of the way, just the usual disclaimer. Any of the opinions that any of the panelists express are obviously their own and don't necessarily reflect their companies. And additionally, as Caitlin mentioned, feel free to ask questions in the chat. We'll be monitoring that and we'll take the questions as they come, or should also have some time at the end for questions as well. So I'd like to introduce now my co-panelists, and I'll just turn it over to them briefly to introduce themselves. So first is Eliar Berzesh, who is my colleague of mine at Unified Patents. Eliar.
Hey, how's it going? Great to be here. Yeah, I'm a colleague of David's, Senior Patent Counsel at Unified, focus on post-grant proceedings, including re-exams and IPRs. Also do a little bit of international opposition work. Was in private practice and worked on post-grant work there as well as patent litigation and prosecution, and also served at the patent office as an examiner for a little bit as well. So happy to be here.
Yep. Thanks, Eliar. Next up on the panel is Phil Eklum. Phil.
Hey, good afternoon. So I am an associate at Reichman, Jorgensen, Lehman, and Feldberg. My practice focuses primarily on patent litigation in the district courts and at the International Trade Commission, as well as related cases, proceedings at the PTO, including IPRs, PGRs, and re-exams. I've also got a fair bit of background in patent prosecution as well. So thanks a lot, David, for the introduction.
Thank you, Phil. Thanks for being here. And finally, our last panelist for today is Lissi Mojica. Lissi.
Good afternoon, everybody. My name is Lissi Mojica, as David said, and I have been working on the patent system for a few years in my life. I left the patent office as director in my 20 years there of the Central Reexamination Unit. And since then, I have been at other law firms, but I am now in my own firm, Answers IP. I have done probably hundreds of post-grant proceedings, thousands of re-exams, which I oversaw. And I am very, very familiar with this process, including IPR, PGR. So I'm really looking forward to our talk.
Sounds great. Thanks. So just to quickly go over the agenda, we'll give a brief overview on re-exams and IPRs, but we're going to assume that most of our audience is familiar with the processes generally. We may spend a little more time on re-exams just because if there is a process that is less familiar, probably would be that. So to start, one of the most basic differences is that IPRs are obviously governed by the PTAB and the PTAB judges, whereas ex parte re-exams are governed and decided by the USPTO's examining unit. And so obviously a re-exam is an ex parte process. And although throughout most of the talk, we'll be looking at it from the perspective of a requester who is filing the ex parte re-exam, I think it is important to note that the patent owner can file their own re-exams. And I think a little bit later, we'll get into some of the reasons why a patent owner themselves may want to file a re-exam and the benefits for doing so. But typically a requester will file the re-exam request, and if it's granted, then the examination proceeds between the patent owner and the USPTO. And so the one of the most basic differences is that the requester has less of a role to play in the ex parte re-examination. So I think there are a couple of interesting things here. This slide depicts the normal process for a re-exam request. And one of the first things to note is that re-exam is ordered when the examiner finds that a substantial new question of patentability, or S&Q, has been raised. And one of the things we see is that the S&Q grant rate, we heard a couple weeks ago at the PTAB Bar Association, we've heard figures such as 92 or even as high as 95% grant rate. And so I was curious of the panelists' thoughts about why the S&Q or re-exam grant rate is so much higher, for example, than the institution rate in IPRs, and also curious how that impacts maybe how you approach a re-exam versus an IPR.
So I'll just give one quick thought on that. So the definition of an S&Q, I think, is probably the reason why the rate is so high. You know, unlike an IPR, the S&Q is more or less showing the patent office that there is something new, you know, whether it's new prior art or even a new argument in the same prior art. So that threshold isn't, I don't think, super high, really. There are things that factor in, like cumulativeness and other things, but those types of differences, I think, are certainly not the kinds of things that meet the likelihood test that they have for IPR. So from a patent owner's point of view, I think typically you're assuming that you're going to get a re-exam order in most cases. Lissi, I know you have a lot of experience in this realm. Do you want to maybe give a thought on that?
Yeah, I mean, unfortunately, the S&Q is a very low bar. So even if you had the exact same prior art, if you're pointing to a separate section of that prior art that was not addressed in perhaps an IPR or a previous examination of the patent, then it's a new S&Q because that portion was not addressed previously or relied upon. So the S&Q bar is a very low bar, which, you know, if you're a petitioner, that really works for you because you can get it through irrespective of how exhausted the prior art is previous to this, if you really believe in that prior art.
Yeah, and I'd just like to add as well, like obviously it's a lower bar, but speed is really, I think, really comes into play as well here, because you can get those SNQs very fast compared to an IPR. And we're probably going to go into that a little bit later on. But, you know, we've had instances where, you know, we filed a re-exam and gotten an SNQ granted in like 3 weeks, which is obviously very quick compared to an institution decision that's going to take possibly 6 months from when you file or when you recorded the filing date. So, you know, I think that kind of plays into the lower bar a little bit, but it's also a valuable kind of tool that challengers or requesters can use when they're considering whether to go the re-exam or the IPR route.
And there's nothing stopping you from filing another one if it doesn't meet that S&Q. They'll give you directions and tell you, okay, you'll get a refund, and then you'll just do it again with the instructions from the examiner saying, you know, you should have done it this way.
So one of the follow-up questions, I guess, then is, since we're talking about sort of the standard for granting a re-exam, how does this approach, or how does this change your approach, if any, when you're drafting a re-exam versus an IPR? Are there certain sections of the re-exam, for example, that maybe you're less concerned about when you're drafting, for example, motivations combined? Are you less concerned with those in a re-exam as opposed to an IPR? And how does that affect how you draft a re-exam if it's different than an IPR?
So I think in a re-exam, you have a lot more room for comfort as far as the rejection goes that you're putting forth, because you don't have a page limit. So you can actually put out there all the information that you need to put out there. And for the CRU examiners, you really need to have motivations to combine and be very thorough about your rejections, because they're not just going to take it up just because, and they're very unlikely to change the rejection for you. So you need to put your best foot forward, and you have the time and space for it. So it's best to put in all the information, you know, put the SNQ and then do the rejection as well. You can't just say, you know, you have a rejection and then say the SNQ is in there somewhere. That's an error that some people make. But
Yeah.
It's a much easier way to do it because you don't have that page limit.
Yeah, and just sort of, touching on that point about not having that page limit and having all that space to make your arguments, you can have a section dedicated to explaining why, this, particularly if there is prior art involved that was raised, previously or in another proceeding, you can explain quite, clearly and with as much words as you like, what the S&Q is, how it's different, how the arguments are different. So to, sort of really help increase your likelihood of getting a re-exam order.
There's one final thing I wanted to note on this slide that maybe some people are not as familiar with. So the boxes that are in dashes are sort of optional parts of the process. And so once the S&Q is granted, the patent owner does have an option to file a statement addressing the finding of an S&Q. I can speak from my practice. In all of the re-exams I've done, I've never had a patent owner file one of these statements. And I think one of the reasons is if this statement is filed, then the requester does get a reply. But I was curious for the panel if you had seen patent owner statements used in any of your re-exams, and if there is, from my perspective, it seems like there's mostly downside to filing a patent owner statement on the S&Q because it does give the requester a reply. But I'm curious if anyone on the panel has had any differences or has found a patent owner statement useful.
Speaking for myself, no, I think my experience is similar to what you just described, David. I've never seen a patent owner statement filed. In the proceedings I've been involved in, we've never filed one either. So I think that's pretty common in any event.
So even in my experience at the re-exam unit, there's very few patent owner statements filed, and it's mostly because the third-party requester gets an opportunity to reply to that. But the reply is limited to whatever you said in your patent owner statement. So if you have like a focused argument that you think the patent office should see before they do it has to be very, very focused, because otherwise it's carte blanche for the third-party, for the petitioner, third-party requester.
Yeah, and I think, like, so same in my practice, I've never had a patent owner statement come in. And obviously, like as a requester, that kind of touches on one of the kind of challenging aspects of re-exams, is that after you file that initial request, you're not really going to get a chance to be involved afterwards. Or you should, I guess, assume that you're probably not going to have a chance to be involved after filing the request. So I think it kind of just goes to what what we've kind of been discussing so far, is that there's no page limit. So it's important to like put your best foot forward and really make sure that you're explaining your motivations to combine and the grounds for rejection that the examiner can just easily use, because you're not going to have a chance to be involved later on.
And you also can have as many grounds as you like. So there's no limit on that.
Yeah, I think those are all excellent points. And by contrast, as Eliar was just talking about, the limited role the requester plays in ex parte re-exam, I'm sure is most of our audience is familiar. In an IPR, it's more traditional process, and where both sides have opportunities to respond and sort of fully vet the issues before a final written decision is issued. So moving on to some of the historical filing statistics for re-exams, one of the things we've noticed over time is that obviously there was a sharp decrease in re-exams when the AIA proceedings were first created, and then it's gone down. But in recent years, we've seen an uptick in re-exams, I think for a variety of reasons, whether re-exam is maybe the only option that's available to a requester, and also a lot of the developments at the board related to discretionary denials, I think may have also been a reason for this uptick. I did want to note as well that we heard at the PTAB bar conference last week that in 2022, I believe the number of re-exams filed was 315. So again, it's still increasing slightly over time. I was curious if any of the panels had thoughts on the recent uptick in re-exams and if you see that trend continuing, and possibly any reasons for that as well.
I think for, from the perspective of cases related to district court litigation, the uptick is consistent with, I think, what folks are seeing out in practice. It's increasingly becoming sort of the go-to way to challenge a patent. Just, I mean, for a host of reasons, many of which we'll talk about. But so I won't jump into those right now. But as far as the trends go, yes, I think, you know, the decline in IPR is a little bit harder to notice, but the uptick in re-exam certainly has been noticeable.
So the other, oh, sorry.
Go ahead. No, the uptick is also, I think, you know, people are seeing these, they may not be getting the results they want. There's some few claims they weren't able to get all the claims in. So they're seeing the speed of the IPR, of the re-exam, you know, as a viable alternative, and they may not have another alternative, as Philip said, but, you know, it's going so quickly. And you can also, if you don't get it right this one time, you can just do it again. So I think that even though there's no third party availability in the one ex parte re-exam, I've been faced as representing patent owner with multiple re-exams when they don't get it right and then they just file another one. So
yeah, I agree. I think that's a good point. Another part of the statistics that the PTO has provided is the historical timing statistics, whereas obviously for IPR, it's a statutory max of 18 months, which is sometimes in reality is 19 or 20 months, depending on how quickly you get that notice of filing date accorded. But I can also say that in some of the re-exams we filed in the past year, this number seems to be much lower than what these statistics would suggest. We've gotten a number of decisions over, say, the past 6 months where the re-exam was only pending for a total of 12, 13 months. And we heard at the PTAB Bar Association conference that within the PTO, the target right now for re-exams is 12 months. And so it seems like anecdotally in some of my own cases that they do seem to be hitting that mark. And so that's obviously a much faster process than IPR. It seems like at the moment. I don't know if the panel has any other thoughts on the timing statistics.
One thing that came to mind was that the statistics, we see some that have been available, since 2008. And I know, that folks that have been in practice longer than that, may recall, some of the timing statistics may have been much longer, in the past or about that long. But if you think about, cases where a party, like a district court litigation where a party has moved to stay litigation, these numbers often come up, right? And historically, one argument has often been, well, re-exam is, it takes a long time, and the how long it takes is indeterminate. You never really know, you never really can tell. But in the last few years, that argument, while perhaps historically true, doesn't quite hold, as David mentioned, particularly when you see the numbers for the last few years, right? 18, 16, 20 months. And, that number does seem to be kind of going down. And so it's an interesting thing to think about. And we'll talk a little bit more about stays in a bit, but that was one thing I think that sort of jumped out.
Yeah, historically, the re-exams took longer because prior to the CRU, there was obviously no control over them. And then when the CRU put them all together, we had to work on the oldest ones. And as we mentioned in preparation, 17 years was our oldest one. So even though the stats look bad, we were actually doing very well getting the new ones out very quickly. So then now it's 12 months to get to final or to NERC, if it doesn't go to appeal. And the appeal itself, the board is doing them within 2 months. So once the board accepts the appeal, it's 2 months. So it's lightning fast, because the appeals, even though they're doing very well with the ex parte appeals from the patent, from the core, they are putting re-exams in a very fast track, and they have a 2-month timeline to pick them up.
And that kind of playing into that a little bit with the district court litigation. I mean, the fact that you're able to get an SNQ granted so quickly can be really valuable, because you then have something kind of in your hand saying this is going to be reviewed before the patent office that you can get in maybe a month, and this is going to be a super short proceeding. I think just that speed and how that plays into the related litigation can be really helpful for a requester.
Yeah, the state statistics for re-exams have really gone up. For a little while, they weren't doing it for re-exams because they were so long, but now historically it's shorter. So the courts are responding to that.
So I think that does lead in well to our next topic. We've kind of just been talking about this in comparing the eligibility and timing between IPR and re-exams. Obviously, IPRs have a lot more limitations placed on them, as we've been talking about. There might be instances where you don't even have the option to file an IPR, whether that's because of a declaratory judgment or the one-year time bar. And to Eliar's point about timing, I think it's when you're a defendant faced with district court litigation, I think it's also valuable how quickly you might get statements on the record by the patent owner about their patent. And so for an IPR, for example, if the patent owner chooses not even to file a POPR, it could be 8 or 9 months before you receive any substantive paper from the patent owner talking about or making arguments on their patent. And so with the re-exam, because for all the reasons we've talking about, that it's much quicker to get an SNQ, that also, as a defendant, would allow you to get statements on the record that could then in turn be used in the litigation. Statements from the patent owner about their patent come at a much earlier time in the re-exam process.
And potentially statements from the patent office itself too. Right. You know, getting just another data point.
Yeah, and the sad thing for the patent owner is that, you know, their statements follow through to the litigation, whereas the third-party requester or the petitioner can argue that it's a different standard, or even though it's the Phillips standard, it doesn't have the same evidentiary requirements. So the third-party requester can have a little leeway, whereas the patent owner, they're his statements. They're their statements, and that's it. They don't have much leeway at all.
And that kind of carries through throughout the course of the parallel litigation, right? So there's no one-year time bar with re-examination. So that problem is a constant problem, you know. So to the extent a late re-exam gets requested, even if the case isn't stayed, there's always this sort of looming issue of, you know, what gets said and how does that impact what's going on in the district court litigation, whether it's related to claim construction or, you know, reasons to reopen discovery or serve new invalidity or, you know, infringement contentions. So it seems to be an ongoing issue.
And I think it is a common trend, and just as a practice point for patent owners, although different courts do vary and how much they want to consider statements in a parallel proceeding. It is certainly, if you are facing a re-exam on your patent in litigation, then I think it's something you definitely need to keep in mind, that those statements you make as part of that, you know, are likely to be used by a defendant.
A really important point, if we go back real quick,
sure.
The anonymity. If you're a requester and you don't want to, you know, put yourself out there just yet, because you know somebody else may be in litigation, but you know it's coming to you, and you just don't want to, you know, put yourself out there. You can do it anonymously, unless you've been in an IPR, and then you have to, you know, put yourself out there. But if you're not involved previously, you can just do it and not have any issues with that.
Right. I think that's a great point, and yet another potential advantage for the re-exam. Again, like we've been talking about, we wanted to touch on the effects that both of these proceedings have on parallel proceedings. Again, the most obvious one is a stay. So I didn't know if anyone wanted to jump in again and talk about what you know, Lissi had just mentioned that we have been seeing that many district courts are now granting stays in light of re-exams, you know, in a similar way that they would to IPRs. But again, just wanted to reopen the discussion to see if anyone else had any other thoughts on this point.
Well, I think one thing to point out, we did touch on some of this, but I guess keeping in mind that some district courts have local rules about when they'll even entertain a motion for stay based on re-exam. Some district courts, for example, their rules might be after a certain point in time following the case being filed or the complaint being served, you have an X number of months before you can request, after which the court will not hear any further, requests for stay. So, but the thing is, though, is that doesn't typically stop, accused infringers from filing them, right? So even if the court won't stay for re-exam, they'll, the request will keep coming, and then you have the ongoing slew of issues that we've sort of been discussing. So I guess one thing to keep in mind is how do the district courts handle the stay issue? Sometimes there's rules, sometimes there's none.
The thing about the re-exam too, if you're going to be filing multiple of them for different reasons, the cost is not going to be as, because the thing is, as we had mentioned earlier, or we had talked about, there's no one choosing one way or choosing the other way. You're going to be involved in litigation, and you're going to be involved in an IPR and a re-exam. We have done statistics that most of the re-exams that were filed, post 2000, I believe it was like 2005, were all in litigation. So like 90-something% of them were in litigation. So you're dealing with two worlds no matter what.
On the kind of cost point, it is kind of interesting to think about that for a requester, your costs are all up front, essentially, at the beginning of the re-exam. I mean, if you're going to be filing multiple, then maybe you have to think about kind of budgeting wise, like when those are going to hit. But that is one of the, in that aspect, like the more predictive nature, I guess, and that you can kind of know what your costs are going to be upfront. It's not like in an IPR where you're going to spend a lot of money preparing the IPR, filing it, and then the briefing might, assuming you get instituted, the briefing is going to be potentially very expensive in terms of attorney fees. So that's also kind of an interesting distinction between the IPR and the re-exam as well.
So yeah, it's just not just the patent office fees, right? It's also the attorney fees.
Everything. So like attorney, like just as a kind of a defendant, like when you're kind of budgeting out your case and the spend, like it's kind of helpful, I guess, to be able to have a little more certainty, maybe, about what your spend is going to be. I mean, it's always kind of a toss-up, but it can be beneficial.
And especially if you're in a case where you may have upwards of 6, 8, 10 patents. So the more patents that are issued in the case, the more desirable that re-exam becomes, because it becomes, like you said, from a budgeting perspective, it becomes much more realistic to actually challenge all of the patents that are in suit, as opposed to a lot of times with IPRs, maybe you just try to go after one IPR against each family or something like that. So I think that's another good point.
And all the claims, you don't have to limit yourself on the claims too.
Right. And this ties into our next point, which is the effects that the parallel proceedings may have on either the IPR or the re-exam. One of the biggest developments in the past several years for IPRs is that we've seen the rise of offensive factors that need to be addressed in any case where there's a parallel proceeding, and also the consideration of when or if to file Sotera or SAND stipulations. And these, to Lissi's point, not only are just something else you have to do for an IPR, but also are taking up word count and may affect your ability to thoroughly develop the issues and challenge all of the claims. By comparison, re-exams are much less burdened by any other parallel proceeding, subject to a couple of caveats that we'll talk about. But just wanted to open up to the panel to discuss some of these issues.
Yeah, this issue, is a living and breathing creature at the moment, right? Director Vidal's issued a few, like at least a couple of, uh, um, I guess, formal guidance memos or opinions about how to handle fintive factors, how the board should handle fintive factors, or how to consider them. So it's sort of an ever-changing process. So something to pay attention to as those decisions come out. But also, the other side of that coin is, flat out, except for some very particular things, the PTO does not consider what's going on in the parallel cases for the ex parte re-exam. So the stage of the proceeding, whether it's very late, it just doesn't matter at all, right? So aside from some particular substantive issues of overlap with maybe IPRs, just it's not an issue there. So you can kind of free yourself from that by turning to re-exam.
Yeah, and I think
Yeah, I mean, go ahead.
No, sorry. Sorry about that. The point I was just going to make was, I think like we kind of talked about the stats on a few slides ago, and I think a lot of that was driven by fintive and kind of the trial dates in district court litigation, which weren't really realistic, which kind of led a lot of defendants to file re-exams because they were worried about being denied at the patent office under fintive. So I think it's actually interesting to see how that's going to play out. And there was obviously the increase we mentioned in 2022. And now in view of the director's guidance, like how that has an impact, if any, on like, re-exams moving forward. As you mentioned, it's kind of a living thing. It's an open question.
Yeah, I write the chapter for post-grant proceedings for LexisNexis, and I have whiplash from how much it's, and it changes. Like I have to do an update like every 3 to 4 months because, one day it'll be this and then the next day it'll be that. And whatever I wrote last time is completely gone. So I think for predictability purposes, as Elliot was saying, we need to, an ex parte makes more sense because it's such an ever changing proceeding at the moment in the IPR world. You're a petitioner, you're following the rules, and then 3 months later, the rules completely change and there's something new going on. Whereas if you don't enter the world of the inter-party review at all and just go ex parte re-examination, you're not going to have the parallel factors that mess up a re-exam, and you can just 12 months and you're done.
Yeah, I was just thinking that same point. There are these considerations, fintive considerations, can cause a party to say, I'm just not going to waste my time with it, or I'm not going to take that spend that money or take that chance right now, and focus on the parallel litigation just because of the probability that it won't get instituted if you think you're going to have a really quick parallel proceeding, a very quick trial date, which happens a lot in lots of jurisdictions. But as Lissi just said, 12 months is all you get, so you do it or you don't. And that decision can be huge. You always have re-exam, but yeah, to the extent you really wanted an IPR, that can be a big decision to have to make.
Yeah, and part of it, I think, and this is kind of going maybe not necessarily on this slide, but I mean, part of just the overall consideration is just going back to the control you want over the proceeding. Like, I think, one of the attractive things about IPR is just that ability to be involved as a challenger. I think everyone has a lot of faith in the patent office. Like, former examiner, I'm not going to be bashing any examiners, they're going to do a bad job, but it can be concerning, I think, as a requester, when you're putting in a re-exam, that because you're giving up so much control, that they are going to come to the right decision. And that's just one of those judgment calls, I think, that you just have to make and try to put your best foot forward.
Well, I hired most of the people at the CRU, so They're
So
not just examiners, they're like super examiners.
they are super examiners, yeah.
And,
All
you
my
know,
interactions with them have been fantastic. So
and it's interesting to me because, like, you know, I represent a lot of patent. I've done both patent owner and petitioner work, but my passion is for the patent owner because I feel like I want to save the patent. But they're not very inclined to. They're more about rejecting the claims. I mean, they get a rejection in front of them, and they're more about rejecting the claims. And it's a very big bar for them to keep whatever the language is. I think the percentages of nothing ever happening in a reexam is maybe like 10%. You know, there's always some kind of amendment, cancellation of claims, or just the patent's gone. So, and I think that that's even a higher rate than what's happening right now in IPRs.
Yeah, more statistics that show up a lot in motions for stay, by the way, just a side note there. You know, when you're considering, you know, whether issues are going to be simplified or not, statistics like that Lissi was just mentioning, you know, often cited for the low likelihood that claims come out entirely unscathed, but they do sometimes, it's true.
Very few though.
One other quick thing I wanted to note on this slide before we move on is I know we're mostly talking about from the perspective of the petitioner or the requester. A couple things the patent owner can do if you are facing a reexam and there is a parallel or an earlier filed IPR proceeding, that is good grounds to either move to stay the reexamination proceeding or even petition to terminate it. And so as a practice point for a requester, it is important, you know, I know it can be difficult sometimes to track the status of a reexam or have to go in and check the docket every day, but it is important because if you are facing one of these motions to stays or a motion to, or a petition to terminate, that is going to be something you want to respond to. And I believe the timeline for doing so is relatively short. So it is something to keep on top of if you are filing reexams, is to pay close attention to the docket and you know, see if any of these motions to stay or petitions to terminate are appearing in the reexams. On the next slide, and this goes to what we've been talking about sort of throughout about the control you have over a proceeding. One of the biggest differences between the two is that in an IPR, you do have the option for settlement. Obviously, this can be, they're almost always granted, except unless you're at a very late stage of the IPR proceeding. Whereas, again, once you file the ex parte request, there's really no option to terminate. And so I was just, as a question for the panel, how does this impact, or how much of a concern is this when you're trying to weigh the two options if you are a defendant in litigation? You know, because to me, this seems like this could be a potentially big deal if you see settlement as a possibility in the case.
I think this is a great tool for settlement because a lot of the IPRs get settled after they're filed. And when you're in settlement negotiations, you can bring up the fact that this is it. We filed this, and it's, you know, you're going to be fighting this battle with the patent office, and there is no settlement option. And then all this prior art will be out there for you. So I've had, you know, much success with the, you know, presenting a re-exam over an IPR because they feel like they can always settle afterwards. So it extends the settlement process a little bit.
Yeah, it's a tough thing to think about when, you know, the prospect of, you know, you may be having settlement discussions on the side, or it may be, you know, a possibility, but once that re-exam request goes out, that's kind of like it's something you can't undo, right? Even if you wanted to. So it's, I think it can have, you know, effects both ways, right? Where if it does get filed, you know, and things maybe had potential for settlement, once it gets filed, that it could take it off the table. It doesn't have to, but it certainly could. You know, of course, the requester isn't involved after that point, so it's kind of like what's done is done, and they don't have to press it any harder, you know. But settlement probably should take into account, you know, the possibility that the requester won't file any more after that, because of course they could at any time. So it complicates things.
Yeah, I mean, I think if there's any kind of saving grace, you kind of have to, as a patent owner, I think the consideration has to be like, we're in this proceeding, we can still amend claims. So, maybe, in certain situations, they can, get something out of it. And then I guess it's a calculus of like, I mean, I don't know, like relative to if you have a situation where an IPR is out there, and it's a strong challenge and it's terminated because you settle beforehand, the IPR is still there. As I think Lissi was mentioning, like it's still just hanging out there. So if you go to try to monetize that patent again, whoever you asserted against is going to look at this IPR and potentially have ideas of where they can go. Whereas at least on the reexamination side, there could be situations where you might be able to still get something out of the patent by just presenting some sort of amendments. Obviously, it's going to be narrowing likely, but you could try to kind of turn lemons into lemonade or whatever. I don't know, like whatever that phrase is, but try to make the best of it. Just a point there.
I think it's a good point. So in the next couple slides, these are a lot of things I think we've already talked about. So I'm going to try to go through them quickly. Obviously, if panelists, if any of you have any comments on this, but there are some obvious differences between participation and word count. I think we've touched on all of these throughout our discussions. Estoppel is another potentially big concern in certain cases. Where the IPR, obviously the final written decision does create estoppel, and the ex parte re-exam, you're sort of free to do with that what you will. So didn't know if any of the panelists wanted to comment on the estoppel issue.
Just one quick add, kind of ties into some of what we've been discussing already. Say there are IPRs and there's re-exam going on. Some cases can be pretty complex, and these situations arise. Estoppel doesn't kill an ongoing re-examination. So if something happens in an IPR and there's a final written decision and there's also a pending re-exam, if re-exam was ordered, it's ordered. So whereas some may take the interpretation that, once estoppel attaches in one IPR proceeding, it may require, other IPR proceedings to be, to not be, maintained by the petitioner. With re-exam, they just keep rolling no matter what. So, and that's because, the office maintains the re-examination. It's not an inter partes proceeding, obviously. So
I have to add to that. If the grounds are exactly the same in both, and the petition, the office comes to a final decision, the board has the ability to terminate the re-exam because they don't want the CRU to come to a different conclusion than they did. So they would if it's the exact same, it has to be the exact same grounds. So they can terminate if the re-exam is under the exact same grounds. And it wouldn't matter if there was an execute or not at this point. It's just a matter of whether it's the same grounds in both the IPR and the re-exam. And then they would have to conclude the re-exam because they don't want the office to come up with two different decisions in the same proceeding, with the same grounds. And the same claims, of course.
Yeah, great point. One other thing too, just we've been kind of focusing on IPRs, but since the Caltech case you see here on the slide on the left, this raises a big issue for PGRs. Whereas IPRs are sort of limited in scope to printed publication 102 and 103 grounds. PGRs, you can bring a lot more. You can bring 112 and 101, and so it's a lot broader. So the scope of estoppel, since that case, there's this question lingering, how broad is it? So I just kind of wanted to point out that if you're in the context of a PGR, the effects of estoppel can be much, much greater than it is for IPR.
And you're taking a broader swath at the whole, what grounds could have been raised in an IPR. So because of California v. Broadcom, they're basically saying, if it's that art or art like it, then you can't bring that up in the court as well.
So the next topic, and again, this is one I think we've been addressing throughout, is the idea of multiple and serial filings. And this is another clear advantage for reexams. We've seen over the past several years that the board in IPRs has been less likely to entertain serial challenges or multiple challenges against the same patent by the same party. Whereas, again, there's no such limitation for a reexam. And in addition, we obviously have a lot of 314 and 325D issues for IPRs that in general are not present in reexams. We'll talk about the Vivint case in just a moment, but I just wanted to see if anyone had anything else to add on this point generally before we move on.
I think the road mapping aspect that, is kind of not really, kind of not really part of the, or not really allowed in the IPR context, is definitely attractive in the reexam context, because I think, as we kind of mentioned, like, you can get feedback from the patent office and then, file another request and kind of just keep that, if you wanted to, kind of keep that rolling and tailor the rejections or the grounds of your request. So I think that on this slide, that's a pretty important distinction in the reexam context.
I agree with that, LER, and I think it highlights sort of, I guess, two ways to sort of approach serial filing with reexamination. There's the idea of trying again and trying again and trying again, but then there's sort of like a turbocharged version of that, which is sort of hovering over the proceedings and quickly coming back with a new request, even with some or a lot of the overlapping art that is finely tuned to what the examiner has said about the prior attempts. So you can have, it's just having that sort of real-time participation, even though by the requester, even though the requester isn't technically allowed to participate. So
yeah,
kind of interesting situation.
I mean, that's a pretty awesome way to regain some of that control you might otherwise lose in the reexam context, because you're essentially having a say by just filing like those staggered requests after getting office actions issued in the in the first proceeding or whatever the prior proceeding.
Yeah, and it's almost unlimited. Harassment doesn't come into play until, double digits.
And so one example of such an instance where a reexam actually was denied is the Vivint case that people may be familiar with. I'll spare going through all of the facts in detail, but essentially someone had tried to file multiple petitions that were denied for various reasons. And then they decided to file a reexam, which was granted. And there ultimately was a final office action issued rejecting the claims. The patent owner appealed, arguing that the 325D or that 325D should apply here and that the reexam should not have been granted. And there the Federal Circuit did agree. So again, this is sort of an outlier and a pretty extreme case to show you what lengths someone would have to go to for a reexam to be denied. But just wanted to, you guys can look over the slides and but didn't know if the panelists had any thoughts in particular on the Vivint case, and if that's changed, whether, for example, you try to address these issues preemptively in your request, if you're in this kind of factual scenario, or anything that changes in how you develop your reexams.
So with respect to 325D, I think that the office has not quite come up with a way to address it yet, because we've had, I mean, I've filed petitions for 325D where there were parallel IPRs that had been denied. And, you know, they tell you that you have to do it beforehand. They tell you that you have to do it after because they can't do anything beforehand. So it's up in the air. I've actually had a couple granted for the re-exams to be under Vivint. So they have taken away the re-exam, terminated it, but it's very up in the air right now, like what the process is, how you're supposed to approach it, where, you know, who decides the 325D petition. This is an area that, you know, as we were speaking of earlier, it's just much cleaner if you start off with a re-exam, because once you've failed in an IPR, there's all these boundaries that you have to cross in order to be able to get into the re-exam process, or just, you know, get yourself out of the situation that you're in. But the 325D can become, and I think will become, a very big hurdle in the re-exams, because, you know, you can't be saying that 325D is effective in an IPR and the same statute is not as effective with a re-exam. So in the end, I think the patent office will do the right thing and say, you know, you picked your forum, you picked an IPR instead of a re-exam, and you're coming here with either the same art or similar art, and no, you shouldn't be able to do that. But if you pick the re-exam to boot from the get-go, then you shouldn't have any of these issues.
I think,
but you do have to put your arguments in right from the get-go and try to put them to the patent. You know, if you're going to put them in as a requester, you should have to, if you have 325D arguments, put them in.
yeah, definitely. You know, and the complexities of the 325D issue are, I think, interesting, because, you know, if you look at the statute, we don't see you don't see in the language some of these issues, like, you know, road mapping and things like that. So the board has developed sort of a body of law interpreting the statute, specifically in the context of IPRs. And so, you know, but when you go look at the statute, you know, you don't quite see some of these specific, you know, concepts or principles. It's their interpretation, more or less. So when we talk about, you know, and I think Lissi makes great point about, you know, what's to come. And I think the answer to that question, you know, whatever it will be, I think things that will have to be considered will be the issue of interpretation, you know, patent office interpretation in the context of IPR, in the context of re-exam. Does that matter? Does that not matter? Should it matter? Should it not? And also what the Federal Circuit has already said in Vivint about those kinds of things, but also what role Congress has to play in this. You know, it's within their power to take a look at the situation and, you know, change the words, not change the words, you know, add something for re-exam or not. So that's a whole nother layer, you know, what Congress may or may not do, you know, to the extent they're following this issue. We've seen proposed amendments that you know, for a host of reasons, you know, didn't get traction, and some of those are political and how they were introduced, you know, omnibus bills and things like that. But you know, how Congress's involvement, I think, will be a very important thing to watch, you know, as things move forward.
Yeah, and I agree with everything the panelists are saying. I think what's interesting about the Vivint case is that, you know, it was a pretty, the facts are pretty, I don't know, out of the ordinary, but you know, you having 3 petitions filed, you know, one denied on the merits, one that filed after that a reference wasn't prior art, and then the third that's kind of like a combination. I mean, I think part of that decision was just like kind of the egregious nature of the petitioning in the IPR that played into the actual ruling there, because you know, that was such a clear kind of corrective action at the PTAB that the petitioner was taking, that I think it just, you know, those facts just kind of led to the decision that you had there. So I think that's kind of what gave it some teeth.
Yeah, but unfortunately, that's not an outlier. The patent office is trying to say that it's an outlier. It is not an outlier. There are multiple IPRs being filed by multiple, even the same filer, different filers. And then when they don't succeed there, they go to the re-exam and they start filing re-exams, you know. So it's not an outlier. I've filed, you know, and just me, my little self, you know, like I guess 8 or 9 325D, more than that, petitions. And, you know, it's because it's really a problem. When people can't, they file the IPRs and then they're stopped from filing those IPRs. They want to bring it down. They just go to the next step because it's available to them.
Yeah.
One interesting, sorry, just one kind of last comment. One interesting thing about the decision was the discussion about the director's authority to launch re-examination at their own initiative. I actually kind of wanted to pose this question to the panel just to, and maybe to Lissi in particular, just like, I've looked up some examples of that happening in the past, and I think I saw one example where it actually happened when there was a really high damages judgment in related litigation, where I think the office, it seemed like, was kind of lobbied to initiate a director re-exam. That situation I can't see that happening like today, but I don't know, like, if you had any thought, if you were aware of that, or had any thoughts of kind of that situation and just kind of your general insights on it.
People try to influence the patent office, and they get, and it shouldn't be influenced that way. So they made a decision that, even though the statute's still out there that you can do director ordered re-exams, it's very unlikely in a situation where it's such a high profile case, because it should only be done by third parties. If you're interested in filing an IPR or a re-exam, then you should file it yourself.
Yeah, that makes sense. I think one of the other examples I saw was for the method of swinging on a swing patent.
Right. Unless it's, if the patent office is a little embarrassed by what's out there.
Right.
Yeah, those they'll still do, but something where there's high stakes involved with people, they're just going to let those people file their own re-exams because they're not barred.
Yeah, makes sense.
So, but before we move on, just a couple sort of key takeaways. I just want to echo Lissi's statement that if you are a requester and you think there might be a 325D issue, even if there's some uncertainty about how it's going to be decided, there's really no reason not to include it in your request. You don't have any page limits. There's really just, if you think there's an issue, there's no reason not to address it. And likewise, if you're a patent owner and you think there's a 325D issue, because this is still seemingly an evolving area of the law, it's something to keep in mind if you are facing a re-exam request. We have a couple of slides here that, again, are just sort of summaries of some of the differences. But there is one major topic with our time left that I wanted to at least touch on, because I don't think we've talked about it too much so far. And that's the difference between the patent owner's ability to get claim amendments in an IPR versus a re-exam. And so obviously in an IPR, in the early days, it was difficult, if not impossible, to have a motion to amend be successful. And there are a lot of other limitations that we list here. Conversely, a re-exam, it's more like a normal prosecution. There's much more availability for the patent owner to obtain amendments. And so the question for the panel is, on the requester side, how much of a concern is this in filing a re-exam? And as a patent owner, how do you approach whether to seek amendments in a re-exam or any of those related issues?
So I think as a patent owner, it's a really kind of exciting and attractive proposition, because essentially, the ability to add new claims is very valuable. I mean, you could tailor those claims, in line with the specification as you kind of see necessary. When you're also involved in litigation, which can be, very valuable, obviously, because you can kind of match up and kind of change the scope a little bit to help you in some situations. I think it's a great tool as a patent owner, and it's like a way to kind of turn the situation and, like, as a patent owner, regain control of the situation a little bit through the process.
Yeah, to echo that a little bit, right? You not having those limitations on the scope of your amendments and ex parte reexamination, aside from the fact that they, you can't make the claims broader, you can address 112 issues that may be lingering in other claims, which can impact parallel litigation. You can add claims, certainly dependent claims. You can add, independent claims that are adjusted slightly, to serve various purposes, and I've seen patents that come out of reexam with, they go in with less than 20 claims and come out with over 100 that are then subsequently relied on. And if there's a stay in the district court litigation, because of the reexam, then that affords some leverage for the patent owner after the fact. So it's I think something that patent owners always think about, fear it a little bit, because if you have to change the scope of your independent claims or asserted claims, that's not great. That can impact damages in the district court litigation, or slow it down or what have you. But there are plenty of positive things, as Eliar said. So
it's a positive and as you said, a negative as well, because you do have those intervening rights. So depending on how old your patent is, if you're amending it to the point where intervening rights kick in, then you're losing a lot of the damages. So it could be both a positive and a negative depending on how old that patent is.
And similarly, I think another thing we wanted to briefly touch on, just because it is related to all these issues, is the availability of a reissue. And this is a proceeding that would be initiated by the patent owner themselves as a way to fix the statutory requirement is an error in the patent. But this can also just simply be satisfied by wanting to seek narrower claims. And so one of the things I think we've seen, even when it comes to canceled claims. So for example, if your patent is canceled as part of an IPR proceeding, during that 63-day window to appeal, the patent owner does have an option to file either a reexam or a reissue to attempt to fix the patent or essentially revive the patent if you're facing a final written decision. So I think this is an interesting tool that patent owners can use if they've already gone through the IPR process and are facing an adverse final written decision. And the flip side of that for the requester is that even if you are successful in an IPR, you may want to keep track of that patent or the family to see if the patent owner is seeking a reexam or a reissue to attempt to revive the patent. So I wanted to throw that issue out to the panel, make sure we touched on it, but see if anyone had any thoughts on reissues or the viability of using a reissue in some of these contexts.
I feel like reissues, if you're as a patent owner, you have to feel like you want to change, like you said, a 112 problem that you have, or because the door is opened on all your claims. If you file a reexam to file an amendment as a patent owner, then you don't take as much risk with the rest of your claims. You're only going to get the claims that you request touched upon versus all the claims in your patent. But if you go reissue and if they just agree that your original claims are still good and you add narrower claims, then you have a super patent there. It's gone through reissue. They've looked at everything again. You fixed any 112 issues. So reissue might be a good way to go. You know, we should talk about the fact of somebody to do a protest in a reissue. You can't do that in a re-exam, but protests are very specific. They have to be within a certain time window under 501, and they really don't have the bite that people think they do. I think that the examiners don't look at them as with the scrutiny that maybe they should look at them. But that, you know, again, they're going to my super examiners at the CRU. So reissues are now. So, you know, it might be looked at.
And so I know we've just got a few minutes left. One other thing I wanted to note in the appendices to the presentation, if this is something that comes up in your practice area or you want to learn more or see what the USPTO has said on this, there are two really good things to look at. In 2019, the USPTO did a study on really the issues that we're talking about today, the interplay between these proceedings. And so there's a link here to that study, and then also to a notice about options for amendments when you have these parallel proceedings pending. And so if this does come up in any of your cases or you want to learn more, I would highly encourage you to read through these two documents. Otherwise, unless the panel has anything else, any closing thoughts about IPRs and re-exams, I just want to thank again Ashley and Virtual Patent Gateway for hosting and having us on the panel today.
Yeah, no, thank you very much. And thanks, Dave, for moderating. Did a great job.